Hi everybody, welcome back to 10 Minutes with Griffin. I'm your host, Griffin Bridgers. For today's episode 131, we're going to introduce the first in a series of discussions on electronic wills. So this is a subject that's very timely, especially given the social distancing requirements with COVID. And while we might see a light at the end of the tunnel, one possibly permanent outcome post-COVID is going to be that electronic wills, maybe even remote notarization, will be a permanent addition to the laws in many states. But for now, we're going to dive into some of the basics behind electronic wills and what goes into them. As always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. So, who does this video help? Well, this is a video designed for clients, advisors, attorneys, anybody who has an interest in learning more about electronic wills and digital wills. Now, this is a basic introduction, so we're not going to get into a lot of the specifics, but what I do intend to do is create a series of videos based on this one where we dive into some of those specifics and the nuances that you need to know in order to have a valid electronic will if it's indeed permitted in your state. And we'll look at where those states are right now that do allow electronic wills. And if you're not in one of the select few, keep in mind that this may be something coming down the pike. So you may want to keep abreast of changes to your state's laws to determine when remote notarization and electronic or digital wills might become a more normalized part of the estate planning process in your state. So, as a starting point, a lot of contracts can be signed online, and that's long been the case, that electronic contracts are recognized under pretty much every state's laws. And the great conundrum here is twofold. One, for things like beneficiary designations, which are contracts that relate to an estate plan, electronic documents are permitted. So, ironically, you can e-sign a beneficiary designation, which is a document that has testamentary effect, but you can't electronically sign a will without getting into the specific Electronic Wills Act and laws that I'm going to talk about in this video and in this series. And the reason for that is that the law of the United States is based on common law from England. And one carryover from that common law are certain formalities that have to be met in order for you to have a valid will. Now, some of those formalities include the following. For one, traditionally the will had to be in writing, on paper, and actually signed in handwriting in order to be effective. Now, there's some exceptions to that have taken hold over the years, and we're not going to really get into those exceptions because we're talking about the norm and the rules here. Another requirement is that typically most wills had to be signed in the presence of two or more witnesses. Those witnesses had to actually watch the testator, who's the person making the will. They had to watch the testator actually sign the will, or they had to be in the conscious presence of the testator, maybe not in the line of sight, but in close proximity where they knew the testator was signing the will at the time. And while all the signatures could be later attested to in front of a notary to create a presumption of validity, the lack of a signature could be fatal to the effectiveness of a will. So because of that, that made it very difficult to create online digital wills that are signed on a website. That's where electronic or digital wills come in, that in order to meet these formalities, there's not a lot of workarounds other than having maybe two witnesses who can prove that they were there, watching you sign on the screen or watching you fill out a digital form. And as we're going to explore here, states have started to expand on that definition and say, hey, maybe we can look at having witnesses present when something is signed on a screen as opposed to being signed on paper, especially in a COVID world with social distancing requirements, where it might not make sense to have witnesses in person watch the testator sign, or a notary in person watch the testator and witnesses sign. Now, it's important to note that this is still a trend that requires written wills. You can't necessarily have a video will like I'm dictating right now and have that be stored as evidence of your wishes in a way that's enforceable. It may create evidence, but it doesn't necessarily create an enforceable will in the eyes of the law in most cases. So, Another problem is that in most states, if you execute a will in one state and then later move or die in another state, most states are going to recognize that will as being valid, even though it wasn't necessarily executed under the laws of that particular state where you might live at the time of death or be present at the time of death. So a big question is, how do you create uniformity so that maybe if you have an electronic will that you sign while you're in one state, it'll be effective in another state. So because of that, there's a need for uniformity, and that's where the Uniform Electronic Wills Act comes in. The Uniform Law Commission puts out a lot of uniform acts in a variety of areas of law, and the Electronic Wills Act is just one example of those that has been proposed to states, which states can enact wholesale or maybe make adaptations. But what we're going to look at next are that some states have adopted some form of Electronic Wills Act, be it the Uniform Act or their own separate laws. And those states include, and this may not be a comprehensive list, but as of the date of this video, based on what I was able to find, those states include Nevada, Utah, Indiana, Florida, and Colorado. There's a number of other states considering it as well. Now, it's important to note that even with an electronic wills law, this doesn't necessarily fully solve the problem because wills typically are notarized as a safe practice. And one issue that's come up during COVID is the ability to remotely notarize documents. Not every state permits the remote notarization of documents. A lot of states still require people to sign in person in front of a notary. Now, in other states, a number of states have adopted the revised Uniform Act on, or the revised Uniform Law on Notarial Acts, which might allow remote notarization, but it's important to note that you have to have both electronic wills and remote notarization in order for this to be fully effective. And a number of states have passed resolutions or executive orders during COVID that would allow temporarily remote notarization and witnessing by video and not necessarily in person, but those are not permanent legal changes. So, as I mentioned, this will be the first in a series of videos on electronic wills, but there's some common elements we're going to see to electronic wills. It's important to note that electronic wills do not get rid of a lot of the formalities that exist under current law. For example, you still have to sign a will in the presence of two witnesses. But what electronic wills change are the medium in which you sign and the definition of presence. You can sign a digital will on a screen and store it as a digital file on a computer or other device instead of having to have an original paper copy sitting around. And witnesses can witness you signing by video in order to meet the formalities of having two or more witnesses. Now, one issue is that in the past, you could notarize, as I mentioned, typically in person. You need to make sure that remote notarization is in place if you want to go that route. And another issue is that in the past, and this has helped a lot with COVID, you don't necessarily have to have the will notarized at the same time that it's signed. So, it's recommended in a lot of cases that there be a self-proving affidavit, but as long as the testator is living, the testator and witnesses are free at any time after a will is signed to go actually have their signatures attested in front of a notary. But that's not the case with a lot of electronic wills laws. Instead, what the Electronic Wills Act states is that the self-proving affidavit has to be signed and executed by a notary at the same time that the will is executed and signed. So you no longer have that lag time. You have to have testator, witnesses, and a notary on the same video call or in the same proceeding to all watch each other affix their signatures. Now, this isn't a perfect panacea. There's a number of limitations that we're going to get into in this series of videos. For one, there's no longer one original paper copy you can rely on. There's the potential for many digital copies to be proliferated with little knowledge or proof of which one might be the original other than who possesses it. Obviously, the form or copy or file in the testator's possession could be presumed to be the original, but this is going to cause a lot of issues when there's sharing of the document, especially because the testator's deletion of the document can be a valid revocation of the will. But with a lot of copies still hanging out there, it can create a lot of confusion and litigation. Another issue is that A lot of other documents haven't kept up. There is no universal rule that allows for electronic trusts and even electronic living wills and powers of attorney. Those still might have to be in paper form, so you may not be able to sign everything in an estate planning package in the same proceeding. And then finally, execution and notarization typically have to be recorded if done by video and not in person. And that can create bad evidence. Even if a testator seems like they know what they're talking about and they know what they're signing and they're of sound mind to execute a will, the way they come across on video could run contrary to that. So it becomes less of a problem of formalities and more of a problem of acting, that anybody can read anything into a video and have more of a justification in their minds to try to contest an electronic will after the fact. So, as I said, this is the first of many videos. I'm going to dive into more of the technical specifics in later videos on this series on electronic wills. But keep watching, there is more to come. And as always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. But thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.